Welcome back to the Law and Crime Network. I'm your host, Caroline Polisi, and court is on the lunch break in the Bob Ward trial. That was a replay of the prosecutor's opening statements, and I'm joined on set today with Ken Belkin, Law and Crime trial analyst. Ken, thanks for being with us today.
Carolyn, thanks for having me.
So I'm just, going back over, we were just listening to the prosecutor's opening statements, and you heard sort of the setting the scene there for that evening. Mrs. Ward was drinking, I think, a $59 bottle of wine. Of course, this is a very high-profile case because the Wards were, by all accounts, millionaires. That's the report goes. Of course, now we've heard a sort of a different side to this story about maybe they were facing some financial troubles. But nonetheless, prosecutors are, throwing that little tidbit of information in there. She was drinking a $59 bottle of wine that evening. Really setting the stage for a dysfunctional marriage. She was on large quantities of antidepressants, and we heard from toxicologists this morning about sort of the levels in her blood. Do you have a sense of what actually happened that evening? I mean, obviously the defense is trying to paint this as a tragic accident, but can you give us like a play-by-play of how you think this happened?
Look, I mean, when it comes down to it, there's only one person that knows what happened that evening, and that's Dr. Bob Ward. And at this stage, I don't even think he probably knows anymore what happened that evening.
Right. Well, one of his stories, right, is that he woke up and, the wine was on him and that this, had transpired while he was asleep. Or take us through the shifting stories of Bob Ward.
That's the problem, is that one of his stories, multiple stories. And, look, he appealed, he got the conviction overturned, and he got a retrial in this case. But the problem is, there's a lengthy record now of statements he's made, starting with his statement to the 911 operator where he said, "I shot her."
Right. I mean, that
pretty glaring admission.
Yeah, I wanted to
right
ask
there.
you about that, and we've played it at this point several times for our viewers, so I won't replay it. But I mean, just the level of sort of flatness in his voice. I mean, it's as if the guy is doing his taxes. I mean, he's not calling to say that his wife has been killed. I mean, it shocks the conscience to hear that.
I think even probably I'm a little bit more passionate when I'm doing my taxes
than
he was on his call.
Right.
But look, someone can construe that as saying this man is traumatized. There was a terrible accident, and his wife accidentally got shot while he was trying to wrest the gun away from her. Now, there's a trial record from the first trial. There's an appeal record. There's statements given to the police shortly after his arrest. There are so many statements here that this man has made to law enforcement. As a defense attorney, you do not want to be trying a case like that because there are so many things that if he were to take the stand, and I believe he's going to have to take the stand in this case really to put forth the defense that he wants to put forth that it was an accident. Well, he's the only witness. What else can they do? There's competing forensic evidence, battle the experts, but he's the one that was there. He's the one who can say what happened, and in order to establish this defense, he's going to have to be the one that tells this narrative. Now, this narrative is going to be compared by the skillful prosecutors with every other thing he has said to law enforcement with respect to this case. And they're going to compare it and look for any inconsistency, and they're going to get him on whatever inconsistencies they can get. And the memory is a fickle thing.
Right, it is. But so take us through, what are these three stories that what are the specifics that he's claimed already has happened that night?
Well, right now, he's claiming that he tried to get the gun away from her, and in the process of getting the gun away from her, it accidentally went off. He originally said that she had shot herself. Now he's admitting to the fact that he shot her, but it was an accident. Probably to deal with the fact that during the first trial, the prosecutors put a forensic ballistic expert on the stand that said there was no way this could have been self-inflicted because the bullet had entered her from the barrel at a distance of about 18 inches or more. So there was no indication that this was self-inflicted. She was shot from a distance that she probably couldn't have reached by her normal arm span.
Right. And so tell us again about the appeal, because I know that there has been some question about that. Why exactly was his first conviction overturned? Why are we having the second trial? Why is he out on bail?
Well, look, there's a lot of reasons I can give you. The one reason I can give you is that the judge did not make a good record here.
Okay, you mean the first time around? The
first time around. Now look, when a judge oversees a trial, you're going by the judge's rules. It's the judge's courtroom. The judge is there to ensure that there's a fair proceeding. And the jury decides guilt. The judge is there to rule on issues of law. Now, apparently during the first trial, the prosecutors made several references that would lead the jury to draw a negative inference from the fact that Dr. Ward at a certain point stopped making statements, invoked his right to remain silent, which every American has. It's Fifth Amendment right, and under that landmark Supreme Court case, Miranda v. Arizona, police are required to inform you of that right to remain silent. Now, no negative inference is to be drawn from you. If I sit down in a room with you and I'm like, Carolyn, why did you kill Aaron Keller? Why did you do it? And you say, you say basically, shh, I'm not saying anything.
Okay.
Nothing can be drawn from that, either good or bad. It's not even supposed to be mentioned to the jury.
I was going to say, moreover, then once we get to trial, you can't then get up and instruct the jurors that, look, she's not saying anything, therefore she must be guilty.
Yeah, and I think the prosecution did that multiple times. The defense attorney did object the first couple of times from what I've read and seen, but the objections were overruled. And the judge pretty much told that defense attorney, look, don't bother objecting. I'm going to let this stuff in. I think the jury should hear this. Whether or not the judge made the right call, I'll leave it up to the viewers.
That's crazy to me. Obviously, the judge did not make the right call.
Well, sometimes judges, they want to get things done. And the objections were noted, and maybe the judge didn't think that the prosecution was introducing it in a prejudicial manner. Maybe they were just trying to establish a timeline. I don't know what the judge's reasoning was.
But that doesn't make any sense, because you can't bring it in, period. You can't bring it in whether or not it's prejudicial. The fact of it is, in and of itself is prejudicial. The fact of telling the jury that he didn't...
It's definitely prejudicial, and I agree. I don't think the prosecutor should have wrote it in. I think it was impermissible. But, the judge let it in. And sometimes judges let things in. And this is why judges sometimes get overruled on appeal, as the judge who oversaw this trial was overruled. And now we've got a new trial, and, we're going to see where this goes. But it's going to be tough, second time around.
Right. You mean it's going to be tough to get the conviction?
It's going to be tough to not get the conviction.
I was going to say.
It's going to be tough for the defense. There's too much material out there on this guy that the prosecution can use. And you better believe now the prosecution has fine-tuned their case, and, it's the defense, really, that's shifting stories and trying to do a totally new case. Prosecution's doing the same old case. They've just had the benefit of learning from their mistakes from the first trial.
Right. Are you surprised that, given sort of, it's rare, as defense attorneys we both know, you automatically appeal any conviction, but it's pretty rare to actually get overturned on appeal. Do you think I think it's interesting. I'm interested to hear your thoughts on why Ward and his attorneys didn't take a deal after this, because they're in a pretty good position thereafter. Once, say, hey, prosecutors, your first case got turned over on appeal because you made some major mistakes. Let's go back to the bargaining table now and get a better sentence.
This guy's got nothing to lose. Really. He's got nothing to lose. I don't think they were going to give him much of a better sentence than what he was going to get at trial. He's got to go forward. If I were him, I'd be going forward. There's nothing to lose in a case like this.
Got it. Let's look back at some of the defense's opening statements, and I want to talk with Ken a little bit more in depth about the 911 call, about admissibility issues there. So take a listen to the defense's opening statements.
Good morning. As I said yesterday, my name is Craig Gillen, and I represent Bob Ward. What happened on the night of September the 21st, 2009 was a very deep tragedy. It was an accident, a tragic, tragic accident that took place in the home of Diane and Bob Ward, that took place in their bedroom. Actually, as you will learn, and this will become important during the trial of the case, it actually took place on Mr. Ward's side of the bed. It took place on Mr. Ward's side of the bed. We'll get into that later. But what happened there was a tragedy. What did Mr. Ward do after that tragic accident? He immediately called the authorities. The first thing that he did was call the authorities. Now, you're going to learn, and we want you to really think about this 911 call. Because what you're going to learn is he actually called 411. In shock, excuse me, stunned, been drinking, maybe slurring his words a bit. So he calls 411. And they transfer him over to 911. And that's when he's talking to the operator. This call is very important. Excuse me. Very important. He says, I shot my wife. And he says in the same call that the state will stress and did stress in their opening and will stress in their closing. In that same call, when he was stunned and shocked, he explained it was an accident. And it was a tragic, tragic accident. An accident, although tragic, is not a crime. An accident, like he told the 911, which the state will serve as the beginning or perhaps the early beginning of their case. His explanation that it was an accident means no criminal conduct. An accident is not a crime. Now and that's really critical when you listen to the 911 tape, to take the entire tape and listen to it and focus on what he says. Because he is the one who voluntarily picked up the phone and called. 411, they switched him over. And he's talking to the 911 operator and explains that it was an accident. Then what does he do? While he's talking to the 911 operator, he wants police to come. That's the reason why he called. He wants the law enforcement authorities to respond to the house. He stays on the call. He's trying to make sure that everything is going to be appropriate when they get there. For example, I can hear the sirens off in the distance coming. He wants to make sure that the gun is put up so that there wouldn't be any question about any danger to the officers. He goes to the front of the house to wait for them, to wait for the law enforcement officers that he called to come to their home and to investigate this tragic accident. The exact description that he gave to the 911 operator, tragic accident. Now, what happened that night? What happened that night? In this case, we're going to really get into some science, and we're going to get into some things the science could have told you, and maybe we wouldn't even be here if the science had been followed properly.
Welcome back to Law and Crime. Those were the defense's opening statements in the second trial for Bob Ward. Prosecutors are going to try to prove for a second time that Bob Ward, in fact, shot and killed his wife way back in September of 2009. I'm joined on set with Ken Belkin, Law and Crime trial analyst. Ken, thanks for being here with us. I don't know how many times I've heard the phrase tragic accident throughout the course of this trial, but the problem I have with that phrase is there's nothing more to it. I would like more of a description. Again, I'm trying to get to the bottom of actually what happened that night, how this could have been a tragic accident, and I think the answer has to come from the forensics. What do you think?
I mean, Carolyn, I have a feeling you're going to hear the words tragic accident many more times.
No.
I think it's going to be repeated ad nauseum in the defense's closing statement.
I don't like it.
Because they want to drill into that jury's head that this is a tragic accident. This man did not take his wife's life. She was whacked out on antidepressants. She was suicidal.
Okay, but let's stop there. Okay, whacked out on antidepressants. Does one get whacked out out on antidepressants? I mean, we heard from the toxicologist this morning, albeit some very dry testimony, but we also have the benefit of the first trial. We have the record there. You don't get whacked out from being on Celexa, do you?
No, you
Right.
don't get whacked
Right.
out from being on antidepressants. And the fact of the matter is, the toxicologist, and look, these toxicologist testimonies are always dry. It's basically
Right.
your high school science teacher on the stand.
Yes.
And if you're like me, your eyes would glaze over during that class.
Right.
But look, the first trial, the toxicologist said, her levels of what they call selective serotonin reuptake inhibitors,
Ooh, good job.
antidepressants,
Yes.
were not significant and not relevant in his point of view. She had the typical levels that one being prescribed these types of drugs would have during the normal course of treatment for depression. So for them to be saying, oh, you know, it's sort of like, it's a little bit insulting to the millions of Americans that take antidepressants and aren't suicidal and, you know, getting mental health treatment. You can be on antidepressants doesn't mean that you're going to take a gun and try to kill yourself.
Right. We saw this in the Michelle Carter case. You know, they tried to make a case for the fact that because she was on high levels of antidepressants, that it somehow had an effect on her. Obviously, it has an effect on your psychology, but that it had this sort of the idea that it could be like a motivating factor behind, just cause you to just go crazy, go off the grid. It just doesn't hold water.
And don't get me started on
Yeah.
Michelle Carter.
Yeah, okay.
I'm in the words "don't kill" camp on that one,
okay.
and she should have been acquitted. But look, just because you're on antidepressants doesn't mean you're suicidal. And his story has changed. He said she shot herself. His phone call said he shot her. You know, this story has evolved over time.
Right.
It's like he's workshopping a screenplay.
Right. And you know, as with so many sort of picture-perfect marriages, again, this is a very high-profile case. This is being billed as, you know, millionaire shoots his wife. We know that there's more to the story behind the scenes to this marriage, and in fact, something was sort of brewing. Tell us a little bit about
Well, there
that.
was, look, the prosecution has laid out a very, deployed a very skillful case that there might have been a motive behind this.
Yeah.
She, a few days after she was shot and killed, was supposed to give a deposition in a litigation that Dr. Ward was facing, and she was about to testify under oath at this deposition that he had blown millions of dollars of investors' money in his businesses on houses and cars. It was not going to be favorable to him. You know, some would call that motive.
Yeah, no, some definitely would call that motive. And, you know, we know that Ward, at least, is trying to say that she was suicidal, kind of grasping on the element that she had been apparently taking antidepressants for, I think, 50 months prior to her death. That is going to be, I think, the defense's sort of rebuttal. But so you told me earlier that you think that Bob Ward is going to need to get on the stand. How do you see that playing out for him?
Not well.
Okay.
I mean, not well at all. I think this guy is going to get on the stand. They've got a wealth of statements that he has given to law enforcement. They've got testimony from the first trial. I'm assuming there were affidavits in the appellate record. You know, they are going to pour over all this stuff. There's going to be a couple of prosecutors at that table that have every single word he has said committed to memory, and they are going to be following along on multiple records to see if what he says on the stand is consistent with statements he's given in the past to law enforcement, and by their very nature they are not going to be, because his story has changed.
So one of the sort of biggest arguments that the defense is putting forth is that, look, you know, they're using what they have, the 911 call, that the infamous 911 call at this point. They're saying, look, but moments after this tragic accident transpired, Bob Ward picked up the phone saying, called 911. Well, we now know he actually called 411. They then connected him to 911. But, you know, this is not the action of a man who is guilty of murdering his wife. He made no effort to conceal the fact that she had been killed with a gunshot. So, I mean, do you think that's true? I buy that to a certain extent, but it can only get you so far.
Look, the defense has a mission.
Yeah.
They need to turn Dr. Ward's original story of suicide into your two favorite words of the day, tragic accident.
Right.
How a suicide gets morphed into a tragic accident, I don't know. Quite frankly, I don't even think the late, great Johnny Cochran could pull that off.
Well, but not a suicide into a trap. It's either one or the other, right?
Well, the first time around, it was a suicide. She's
right.
suicidal. Now they've got to turn it into a tragic accident.
Right.
It wasn't a suicide. She was suicidal. I was trying to stop her. You know,
yeah.
It was an accidental discharge.
Right.
You know, this is all to accommodate the fact that forensic evidence from the first trial said that the way the gun was fired was not indicative of a self-inflicted gunshot wound.
So I want to talk about that because I want to go back over some of the forensics, the testimony that we heard this morning about how they swabbed. We heard from a forensic examiner this morning that they actually combined two swabs from the trigger and the grip of the gun together. And I think the defense is trying to poke holes in the way the prosecution went about doing this investigation, saying that, well, you know, that you contaminated that, you know, sample. We now know that that's not the way people in labs go about testing these things anymore. They don't combine two swabs, but I don't know if that point, I mean, look, maybe they'll bring that point up in closings and clarify a little bit better for the jurors because it was so dry. But do you think there's like a slam dunk case here for botching of the crime scene? I mean, that's sort of a classic trope we see a lot of times, the defense trying to argue that, you know, the crime scene was compromised, therefore we can't take anything that the investigators say as truth. Do you think that worked this morning?
This is like a textbook example of a defense attorney trying to put a legal question onto the jury.
Yeah.
The jury's there to answer factual questions about the night in question. Now look, if this stuff was botched and this evidence was tainted, this is stuff that should have been brought up pre-trial and should have been suppressed at an earlier hearing or on motion. Clearly, they were not able to do that, so now they're trying to put it in front of the jury to try and muddy the waters.
Yeah, I'm interested to see sort of how they are going to string this together in closing statements for the jury. With that being said, I want for our viewers to hear again the infamous 911 call because you just can't hear it enough times because it is going to be, I think, the nail in the coffin for Bob Ward. So take a listen to his initial 911 call in 2009.
Emergency.
I just saw my wife.
You just what?
I just saw my wife.
Where's your wife?
She's right here on the floor. I just saw my wife.
You just shot your wife?
I saw my wife, yes, please, since whatever. I just saw my wife.
Okay, where's the weapon?
It's in the,
Yes.
I'm sorry.
Where is she breathing?
No, she's dead.
You know that for sure.
I think so, yes.
Okay, sir, where's the weapon?
It's in the nightstand next to the master bedroom. I'll be glad to meet the officer that comes forth.
Where is your wife, sir?
She's on the floor in the master bedroom.
She's not breathing or?
She's dead. She's done. I'm sorry. I'll be able to go. It's fine. No weapon, no woman. I'm fine.
Okay, so we're on our way.
Thank you so much.
Sir, did you purposely do this?
No.
Or was it an accident?
It was an accident.
All right, that was Bob Ward himself in the 911 call he made the night of his wife's death. I'm joined in studio with Ken Belkin. Ken, what do you think?
What do I think?
Yeah.
I think, first of all, this guy said no less than 7 times,
Yeah.
I shot my wife.
Right.
I'm sorry. You don't say I'm sorry unless you did something wrong, right?
Yeah, I mean, I think so.
Doesn't
Devil's
sound like
advocate. No.
Tragic accident. The
Right.
word accident itself
Right.
did not leave his lips
Not in that call,
phone
but
call.
she does clarify at the end. She says, "Did you do this on purpose?" He says, "No." She then prompts. She says, "Was this an accident?" He says, "Yes, it was an accident." Not very persuasive. I agree with
and
you.
not his words.
Right. No, I agree with
That's
you.
a leading question.
Absolutely.
You know?
Yes. But again, that's not in a courtroom. But
Well, by now,
yes.
well, I would say by now, it's probably,
Yeah.
you know, you're well into this conversation. It's starting to dawn on him the potential consequences for his actions.
Right. I think, you know, the defense's rebuttal to that would be that, you know, she was in shock. He had a lot of alcohol that evening. You know, in his system. I want to play for our viewers again some testimony of Officer Michael Mandarano. I don't know if I'm pronouncing that exactly right, and then we'll come back with Ken Belkin to discuss it.
And I'm currently a corporal with the Orange County Sheriff's Office.
Now, back in 2009, were you also employed with the Orange County Sheriff's Office?
Yes.
All right. And how long had you been employed with the Orange County Sheriff's Office?
In 2000, I started in December of 2006, so it would have been about 3 years.
Now, during that time, on September 21st of 2009, what area of patrol were you assigned to?
I was assigned to what's called our Sector 3, which is the Pine Hills area of Orlando. They break it up into sectors. It's just a geographic area to spread manpower.
Now, on September 21st, 2009, did you respond to a call for service around 7:45 that evening?
Yes.
All right. And where was that call for service?
It was in the Islesworth subdivision off of Conroy Road.
All right. Now, I'm going to go out on a limb. Islesworth is probably not in Pine Hills. How come you responded to that location?
I was actually on dinner break at the time. I was eating at a Jersey Mike's down the street on Conroy Road. And like I said, we were on break, but the call came out. And due to the nature of the call and our proximity to it, myself and the other people I was eating with decided to respond.
All right. And who were you eating with?
Deputy Corey Legg, Deputy Ray Bagley. I believe that's it.
Now, were you in standard Orange County Sheriff's uniform?
Yes, sir. I was dressed in uniform.
All right. Similar to what the court deputies are wearing here today?
Yes, sir.
And driving a patrol car?
Yes, sir. Marked patrol car.
All right. So marked patrol car, lights, agency insignia on it and everything?
Yes, sir.
Now, when you respond to a call like this, what type of call did you receive, actually?
It was a call. So we get it through our dispatch. It comes over our radio. And it was an aggravated battery via gunshot. And we got information that the person calling it in had said he had shot his wife. So it's a code 3 call. It's just it's a call we can turn our lights and sirens on. We can, safely disobey traffic laws, all that stuff. So it would be a call that we would respond to in emergency mode.
All right. And did all 3 of you respond to the Islesworth community?
Yes, sir.
And when you got to the Islesworth community, did you have any issues coming through the gate?
No, sir. We told the guard gate that we were there for an emergency call, and they let us in.
Now, when you came through the gate, did you have any difficulties locating the property?
Because I worked in Pine Hills, I wasn't overly familiar with Windermere or Islesworth, so I was trying to pull it up on a map. Deputy Legg was more familiar with it, so at one point he had went around me and drove down the main road, and I followed behind him as we attempted to locate the address.
Did you guys end up overshooting the target location?
By a little bit, not by much.
All right. Now, that call for service that you get out that allows you to kind of code 3, kind of disobey the traffic laws, all the fun stuff of being a cop, does that cause you some concern when you actually have to arrive on a scene like that?
Yes, because when you're going to a call that's in progress, which is usually what happens when it's a violent felony or any type of in-progress crime, the lights and sirens could alert the suspect to your arrival and could make it a safety issue for you once you do show up.
Now, when you exit your patrol car, do you take out your agency-issued firearm?
Yeah, once we determined we were at the correct location, we actually saw an individual standing near the driveway. We got out, and because of the nature of the call, it was a shooting, and the suspect was supposedly calling it in. We did take out our firearms, and we took a position of cover so that if we were shot at, we would be able to return fire and do what we needed to do from a safe location.
Now, did you issue commands to the individual that was at the end of this driveway?
Yes. So I saw a white male standing near the end of his driveway. He had 2 things in his hand. One looked like a phone. It was lit up to his head. I couldn't tell what the other object was. So from where I was standing, I started to yell at him to get down on the ground, to drop what he had on his hand, and to listen to our commands.
Did he have some difficulty complying with you at first?
Yeah, initially I would tell him to turn away from us, and he would face us. And then I would tell him to lay down on the ground, and he would do it, and I would say, put your hands behind your back. He would stand up and walk back towards the house. It's almost like he was doing the opposite of what I was saying. He wasn't being aggressive or verbally. He wasn't being rude, or he was being compliant, but he was just having difficulty following my instructions.
Now, was anyone shouting different instructions than what you were issuing?
Deputy Legg was near me behind the tree. We were probably both yelling things in the heat of the moment, trying to get the situation under control. But nobody would have been yelling the opposite. And for the most part, I remember being the main person yelling.
Now, were you the one that actually approached the defendant?
Yeah, once we were able to get the items out of his hand and we determined that we could see his hands, Deputy Legg covered me, and I went in and got him on the ground and ended up securing him in handcuffs.
Now, the person that you handcuffed, do you see him in the courtroom here today?
Yes, yes I do.
He's doing the courtesy of standing up for you. Is that the individual who stood up? Is that the person
Yes.
that you handcuffed at the end of the driveway in Ellsworth?
Yes, sir.
And that's located here in Orange County, Florida?
Yes, sir.
Now, when you were handcuffing him and taking him into custody, could you smell the impurities of alcohol?
Yes, I did.
And what about his eyes? Did you have an opportunity to look at his eyes?
His eyes were glassy. I did have a very, very brief conversation with him after I handcuffed him. Some of his words were a little bit slurred, but his eyes were glassy and he smelled like alcohol.
Now, when you have him secured, what do you do with him?
At that point, I need to get him away from the front of the house. We're still investigating the shooting crime. And obviously his safety, our safety, we need to move him away from the front of the house. So at that time, we're also trying to find any potential victims or additional suspects. So in the interest of safety, I asked him, is anybody else in the house? He answered that his wife was in the house. I asked, where's your wife? And he said, she's dead. I said, okay, but where is she? And he said, up in the master bedroom. So as I continued to move him away, it was just gathering facts so that I could relay it to additional responding deputies so that we could be as safe as possible and keep the community safe as well.
Now, was this a normal-sized house?
No, sir.
How would you describe this house?
It was a very large house. It had, it was probably almost 8,000 square feet. It had like a separate walkover to like a different part of the house with more rooms. It's a very, very large house.
All right, and with it being such a large house, does it take more deputies than normal to conduct what's known as a protective sweep of the residence?
Yes, sir.
All right, and were you able to eventually do a protective sweep of the residence?
Yeah, once we got enough deputies that we felt we could safely do the protective sweep, we did conduct it.
Fine. Now, did you have an opportunity to see the victim in this case?
Yes.
All right. Can you tell the jury where you located her?
She was upstairs. You kind of had to walk up the stairs and around to, I guess, what would be the master bedroom. From the master bedroom door, you could partially see her body. It was sticking out from behind like an architectural wall that curved around. She was laying on her left side, and her left arm was out, and the back of her head was kind of facing the entry to the master, if that makes sense.
Was it obvious to you that she was deceased?
Yeah, as we got closer, she didn't respond to any commands, and we could tell she was deceased.
Now, did you touch her at all?
I did not.
Did any other deputies touch her at all?
I don't know.
Now, when you leave that bedroom, did you go outside on the back patio?
Eventually, yes, we made our way to the back patio.
Just a moment. All right, just a moment. Your Honor, permission to republish a portion of State's 6 that's already been
Brandon?
Now,
Hold on, it's not up for the jury yet. There it is. Go ahead.
it's up. All right, thank you. Now, Deputy Mandarano, if you're looking at State's 6 here in evidence, it's photographed, the last digits are 356. There's an individual with shorts on and a shirt. Do you recognize the back of that individual?
Yes, that was him the night of the incident.
Okay, him being the defendant here today?
Yes, sir.
And the defendant is James Ward, the individual who stood up earlier?
Yes.
All right, now, did you have an opportunity to get a good look at that stain on the back of the shirt?
When I saw it, it was right after I'd handcuffed him and was moving him to a safer location. It was pretty dark out there. I'd noticed it. I initially thought it was blood, and then I'd given him his glasses back later after we had cleared the house, and he had his back to me in the car, and that's when I had seen that it was probably wine or some kind of food-colored or colored liquid drink.
All right, and the colored liquid drink or possibly wine, did you see that spilled out elsewhere in the house somewhere?
Yes, when we had made our way out to the back patio, there was a broken glass of wine, and there was spilled wine.
Now, you said you gave the defendant his glasses back. Did you give him his phone back, though?
No, I didn't touch his phone.
Where did his phone remain?
He had put it down in the driveway, if I remember correctly, and was still holding the other object, which at the time didn't know what it was. He had eventually put that down. That's when I handcuffed him. When I had gone up to him, that's when I realized it was glasses. And he had asked for his glasses back, said he couldn't see, so I got him off the ground and put him on his face.
Thank you. Just one moment. Nothing further.
Cross.
Good afternoon.
Good afternoon.
My name is Craig Gillen. I don't believe that we have met.
No, sir.
Just have a few questions for you. You indicated that you responded after, I guess you were having, you said lunch, but it's fairly late for lunch.
Welcome back to Law&Crime. That was Officer Michael Mandarana testifying to what exactly he witnessed that evening. Remember, he was one of the first responders on the scene that night, saying he saw the bloody body of Diane Ward there in the bedroom. He saw the broken wine glass on the patio. I want to play for you now a clip of the forensic scientist, Beta Vita. She's going to testify exactly to what actually happened from a forensic standpoint that evening. So take a listen.
And prior to working for the Las Vegas Police Department, where did you work?
I worked for the Florida Department of Law Enforcement in Orlando as a crime laboratory analyst.
And in which section?
Biology.
And does that involve doing?
Can you move the microphone a little bit?
Sure.
Try it now.
All right, you mentioned you work at the Orlando office of the Florida Department of Law Enforcement. In what division?
DNA biology.
And tell us about your educational background.
I have a Bachelor's of Arts in Biology with a minor in Chemistry from Minnesota State University, Moorhead. And later on, I also received my Associates of Science degree in Crime Scene Technology.
And was your first job in this field at the FDLE?
Yes.
Is there any sort of additional training they give you, or do you start on casework with your bachelor's degree and your degrees?
Absolutely. When I started at FDLE in December of 2005, I went through a documented and formal training program that lasted a little over a year. During that time, I did a lot of reading on DNA, serology, and worked on a lot of samples that we commonly encounter in the laboratory. In addition to that, I took a number of written and oral exams, and then I was required to work with another experienced analyst for 6 months after that under supervised casework, and then I also had to pass a competency test before I was allowed to do casework on my own.
And would they ever give you some proficiency tests along the way so that you could maintain your status as a caseworker?
Yes.
And tell us about that. How would you get these tests?
A proficiency test is basically a test that is sent to me from an outside agency, and it's a mock case with mock samples, and I would work it just like I would a regular case. Once the case was finished, I would write it up and send my answers back or the results back to this agency, and there they would check it to make sure that I got the results that I was supposed to. And I did that twice a year. I still do that twice a year.
And the Florida Department of Law Enforcement lab itself, does it enjoy any accreditation?
Yes.
And from whom?
ASCLD Lab, which is the American Society of Crime Laboratory Directors Lab Accreditation Board.
And do you have to meet, what sorts of standards do you have to meet to get an accreditation from that society?
They have been accredited since 1990, and basically accreditation is a voluntary program that any laboratory may join to show that their personnel, operations, management meet specific standards.
All right, and in addition to doing testing for DNA, do you also do any serological testing for things like blood, semen, saliva?
Yes.
And what steps would you take first in the process? Would you do that serological testing to search for potential sources of DNA first?
Yes.
All right. Now, when you do some casework in the Florida Department of Law Enforcement lab, how is it that you get any particular item in your hands to do the work?
So all the cases that I had were randomly assigned to me by my supervisor, and I would request the evidence, and then the evidence would come to me from downstairs, and I can go into how the evidence came into the laboratory if you'd like.
Is this lab a secure facility, or can I just come in and pick up some DNA and take it home and bring it back?
No, it's very secure.
All right, now when you're doing this sort of work, what are you wearing? Not like your suit, I'm talking about like protective clothing for both yourself and the evidence.
Yeah, so we try to not only protect ourselves from blood and other blood fluids we look at, but we also try to protect the evidence. So whenever an evidence is being worked on, I always wear a lab coat, a hairnet in some cases if there was hairs involved, gloves, and each individual case is worked by itself. Each individual evidence is worked by itself. And when we're working question samples, we would work it different from known samples.
Do you sterilize your work areas?
Absolutely.
Do you have vented shafts so that the air goes up and out of the building instead of all over your lab?
Yes.
Do you wear anything when you're doing DNA work to cover your mouth and nose?
Yes, we also wear masks.
All right. So let's talk about DNA. You ever heard of that?
Yes.
What is DNA?
DNA stands for deoxyribonucleic acid, and it's the blueprint or set of instructions that codes for everything in the body. It's found in cells, and its purpose is to pass down genetic information from one generation to the next. And everybody has their own unique DNA, except identical twins, and you also get half of your DNA from your mom and half of it from your dad. And it's also consistent throughout your lifetime, so it never changes.
And so are most cells in our body, do they contain this DNA, this nuclear DNA that we're talking about?
Yes.
Are there some cells that don't?
Yes.
And what would those be?
Red blood cells in the blood.
How about skin? First of all, would you agree that there's many layers to one's skin?
Yes.
All right. Tell us about skin and how one may or may not get nuclear DNA from skin.
So skin cells are basically cells that cover either the outside of the body or also inside the body, organs and things like that. And the skin cells contain cells that contain the DNA. And the way we refer to touch DNA, or this type of DNA, is touch DNA because it's through skin. And
the prosecution's defense is here to the defense's argument that they didn't treat this crime scene carefully enough is that a husband and wife can their DNA is going to be all over each other
Yeah, and
anyway.
everything.
So it would be very difficult it's their home. It'd be very difficult to prove just based on, isolating out somebody's one of their DNA. The fact is, in all likelihood, both of their DNA is going to be on everything in this house, right?
Yeah, I mean, look, this DNA stuff, it's not the smoking gun we make it out to be.
Okay.
We all have DNA on us from people we have never even met, let alone those closest to us and live in closest proximity to us.
And yet, the defense is trying to make this pretty intricate argument that hinges on DNA,
Yeah,
isn't it?
well, the defense is doing this. They're
right.
poking holes. They're
Yes.
poking holes everywhere they can poke a hole.
You
they're
just ruined.
poking
You just
holes.
ruined all your notes there.
I ruined my notes. It's happened before, but I have a very good memory. But look, they're poking holes. They're trying to get that reasonable doubt into this proceeding. A very famous defense attorney in New York City, Murray Richmond, always said, give me a pinhole and I will wheedle it to the point where I can drive a Mack truck through it. And that's what they're trying to do. They're trying to inject reasonable doubt here. They're trying to make the jurors think.
Yeah.
Maybe, this investigation wasn't conducted with the scientific rigor that an investigation of this nature should be conducted with. Maybe, he was in shock and he didn't know what he was saying on the 9/11 call. Maybe, by virtue of the fact that his wife takes antidepressants, she was depressed and suicidal. Never mind the fact that she'd been treating her depression issues for 50 months.
Right.
And according to the prosecution's expert, the levels of antidepressants in her blood were insignificant and irrelevant.
Right. We heard this morning again that those levels, no big deal, just as you said, not a big deal according to the expert who testified this morning. But then you heard the defense really try to get in there saying, well, you can't say for certain whether or not this may have had an aggressive, that one of the outcomes of this level of the drug in her system, maybe it could have led to aggression, and the examiner had to admit that, that potentially could have been sort of...
Yeah, maybe in 1 in 1,000 cases.
Exactly. I want to finish up the testimony of the forensic psychologist, Bita Vita, so we'll talk on the other side. Welcome back to Law and Crime. We are just moments away from going back live in the courtroom of the Bob Ward trial out of Florida. I'm joined in studio with Ken Belkin. Ken, thanks for being with us today. We just heard from Bruce Goldberger. We were showing viewers a replay. He's a forensic toxicologist. He was on the stand earlier today. And he said that the level of trazodone in Diane Ward's system post-mortem would have had absolutely no effect on her. That's got to be devastating for the defense.
Yeah, I mean, this guy testified credibly. He was very easy to understand. I mean, he should go into teaching if he hasn't already, because I feel like he's made me an expert on post-mortem diffusion of drugs in the system.
Right.
Victim. He said, look, it's the levels they tested it at were not even within the therapeutic levels that one would normally have in their system. There is some difference when you test for drugs post-mortem. He said, things tend to diffuse, but he didn't think there was any chance it would have affected behavior. Right.
So I was interested about this, as he said, post-mortem drug redistribution, meaning the drugs, the level of the way the drug is metabolized in the system can vary depending on the time of death and where it was sort of broken down in the system. But nonetheless, it sounds like the end analysis here is that the overall levels of trazodone don't come anywhere near to having an actual effect on her. So I think, the bottom line for the defense is they can't use this trazodone as a reason for why she would have gone crazy that night to try to kill herself.
Now, I've worn the prosecution hat a lot today.
Okay.
I am a defense attorney,
Yes.
and I am going to put the defense hat on for
Please
a second.
do. Please do.
He says that when you test for drugs in a living subject relative to a deceased subject, in the deceased subject, the drug gets diffused throughout the body. Now, trazodone is ingested, it's metabolized through the liver, and goes into the bloodstream from there. Now, in this case, he said on the stand that when someone is post-mortem and they test for drugs, it will diffuse through the body. It'll move from vessels to tissue, stomach to GI tract, to form an equilibrium in the body. And so the levels could be compromised a little bit, and it's not, you heard him also say that he could not say for sure what her levels were when she was alive.
Right.
Now, a skillful defense attorney will run with that and say, look, even though you're saying the levels you found on her post-mortem weren't enough to influence behavior, you're not capable of knowing what her levels were while she was alive that night. And he would have to say, you're right, I do have no way of knowing that. And he did sort of concede that. And I think you can spin that and say, look, she was dead when they tested it. The drug had essentially diffused throughout her body. That may show a lesser level than was actually present in her body on the night of the incident.
Yeah. Let's see where he's going with this. I want to show viewers the rest of Bruce Goldberg's testimony. He's the forensic toxicologist about the levels of these drugs that were found in Diane Ward's body. We're going to take you live to the courtroom just as soon as they come back from their lunch break. So let's see if we can get in the rest of this clip before that.
Okay. Now let's talk about citalopram. Are you familiar with that substance?
Yes.
And I believe that it comes under a couple different brand names, but are you familiar with a brand name variety of it called Celexa?
Yes.
All right, what can you tell the jury about this substance, citalopram, that comes in the form of Celexa?
Citalopram is also an antidepressant, so the effect on the body is similar to trazodone, but it is more effective. But it's also more safe. So the newer generation antidepressant drugs that were introduced 20 and 30 years ago, these are called serotonin reuptake inhibitors drugs, or SSRIs. They are more safe. It's more difficult to overdose with these drugs, but you still have the antidepressant effect.
And just briefly, what is serotonin and what is SSRI?
Yeah, so it's a selective serotonin reuptake inhibitor, SSRI. Serotonin is that neurotransmitter in the brain that makes us feel good. We're less depressed if you have normal levels of serotonin.
And so how does this drug work to make people who are less happy more happy?
Because it stops the reuptake of the serotonin in the brain, in the nerve system, in here.
All right. So for me, Friday is my day to take the garbage and the recycling bins out. So are you saying that our body has this process where you have serotonin and it needs to get taken out to the curb every so often, so to speak? Is it something like that?
Well, there's a constant process of production of serotonin and a turnover and reuptake of the serotonin in the neurotransmitter system. So what this drug is, it slows down or prevents the reuptake of the serotonin, so you end up with increased serotonin in the brain, and therefore less depressed. That's the goal.
Okay. And besides being used as an antidepressant to treat depression, which is a sad mood, right?
Yes.
Does it have any other uses?
Not really. Citalopram is principally an antidepressant drug. Some physicians may use it to stabilize mood. So maybe it's not necessarily a depressant type mood, but it could be used or maybe termed as a mood stabilizer. It may also be used in a patient who's being treated for anxiety. But it is, by definition, an antidepressant drug.
All right. And in the blood sample that was drawn from Mrs. Ward and sent off to the toxicology lab, was there a reported value for citalopram in that blood sample?
Yes.
And what was that level according to the lab?
840 nanograms per milliliter.
And just really quickly, what's a nanogram? How does that relate to grams, micrograms, and then is it milligrams? As we go down?
Milligrams, then micrograms, nanograms. It's a figure. You can't see a nanogram.
Welcome back to Law and Crime. We are live in the courtroom of the Bob Ward retrial for the murder or tragic accident of his wife, Diane Ward. Let's take you live to the courtroom now.